I've signed my name to a great many things over the years: mortgage releases, incorporation papers, the quiet documents that transferred my late husband's pension into my sole name after he passed. Each one felt like a door closing behind me. Not sadly, just completely. I've always been a woman who prefers a closed door to a half-open one. Certainty is something I learned to build for myself, the way you build anything that matters, slowly, carefully, with better materials each time. My name is Evelyn Marchetti. I'm 63 years old. I live in a stone-fronted townhouse in the Glebe neighborhood of Ottawa, 2 blocks from the canal, which I bought 14 years ago when the market was sensible and my patience was sharper than most people's urgency. I spent 31 years as a senior archivist at Library and Archives Canada. I know how to read documents the way other people read faces. I know where things are hidden, and more importantly, I know why people hide them. Today I am not at work. I retired 4 years ago and have not missed it the way people warned me I would. What I do miss, occasionally, is the smell of old paper. That particular smell, dry and faintly sweet, like something preserved past its season, that I still find comforting in a way I've never fully explained to anyone. I am at the offices of Halstead and Bryce, barristers and solicitors on Metcalfe Street because I received a letter 3 weeks ago on firm letterhead requesting my presence at the reading of a will. The letter addressed me by full name, Evelyn Grace Marchetti, which is not the name I go by professionally or socially. It is the name on my birth certificate. I noticed that immediately. The receptionist leads me to a small boardroom with a window that looks out onto the street. There is a water carafe on the table and 2 chairs arranged across from a single chair behind a narrow desk. I sit in one of the 2 chairs and do not touch the water. I have been in enough institutional rooms to know that the water is there to make you feel at ease. I don't need to feel at ease. I need to pay attention. The lawyer who enters is perhaps 45, with dark-framed glasses and the particular manner of someone who has rehearsed what they are about to say. His name, according to the business card he places in front of me without being asked, is Paul Bryce. He sits. He opens a folder. He looks at me the way you look at something you expected to see but still find startling. "Miss Marchetti," he says, "thank you for coming. This is an unusual situation, and I want to be transparent with you about that from the beginning." "I appreciate that," I say. "Please go ahead." He tells me that the estate he is administering belonged to a woman named Constance Aldridge Fenn. She passed away in February of this year at the age of 88 in a private care home in Westmount, Quebec. She had been a professor of literature at McGill University for over 30 years. She had never married. She had no children that anyone in her life had known about. He pauses here in the way that people pause when the next sentence requires preparation. She did, however, leave a will, he says. A will that was updated 14 months before her death, and that directs a specific portion of her estate to be held in trust and transferred to a biological daughter she placed for private adoption in 1960. He folds his hands on the folder. There is a secondary document attached to the will, a personal letter that names certain identifying details, a birth date, a physical description, the name of the Ottawa family the child was placed with through a private arrangement. He looks at me steadily. "Miss Marchetti, your birth name is Evelyn Grace Holbrook. You were adopted at 9 days old by Bernard and Louise Holbrook of Ottawa in the spring of 1961. You took your husband's surname upon marriage in 1987. He pauses once more. You were born on the 14th of March, 1961. The child named in Constance Aldridge Fenn's letter was born on the 14th of March, 1961. The room is very quiet. Outside, a city bus passes on the street. I can hear it the way you hear things when your attention has gone somewhere else entirely. I do not reach for the water. I look at Paul Bryce and I say, "What's in the letter?" He slides it across the desk to me. The paper is cream-colored and slightly brittle at the fold lines, the way paper becomes when it has been handled repeatedly over many years. The handwriting is precise and academic, the kind that comes from a generation taught to write as though permanence mattered. It is addressed to no one by name. It begins, If you are reading this, then the door I left open was found. I read every word. I read it twice. Then I fold it along its original creases and set it on the desk in front of me, and I look at the window for a moment. "What is the estate?" I ask. Paul Bryce opens a second page. A collection of approximately 4,000 rare and annotated volumes housed currently in a climate-controlled storage facility in Montreal. A set of unpublished manuscript drafts, 17 in total, spanning her academic career. And a property, a small heritage house, on the shores of Bras-d'Or Lake in Cape Breton, Nova Scotia. She acquired it in 1978 and has maintained it through a property management arrangement ever since. He pauses. It is assessed at current market value considerably below what it would sell for. The Cape Breton market has moved significantly. I look at him. Who else knows about this letter? He doesn't hesitate. One other party, a former doctoral student of Professor Fenn's named Gareth Soloway. He served as her literary executor for the past decade and was present when the updated will was filed. He was notified of this meeting. He was notified that I exist, that you might exist, that the biological daughter clause had been triggered by a potential match. I pick up the letter from the desk and put it in my bag. Paul Bryce does not object. He has the expression of a man who expected this and finds it appropriate. I drive home myself. I have always driven myself. My husband used to say I drove the way I read purposefully, with no unnecessary stops. He meant it affectionately. I took it as one. At home I change out of my good coat and make tea properly. In the ceramic pot my mother gave me the year I started at the archives. My adoptive mother, Louise Holbrook, who sat me down at the kitchen table on the evening of my 12th birthday and told me, calmly and with the specific tenderness of someone who has been saving courage for years, that I had been placed with them as an infant by a private arrangement, that they knew almost nothing about my biological mother, and that none of that changed anything that had already been built between us. I asked questions, the way 12-year-olds ask questions, which is urgently and without precision. And then, as the years went on, I did what most people do. I built a life with the materials I had. They were good materials. My parents were good people. I did not spend decades grieving an origin I had no access to. But I had kept that birth certificate, the one with Evelyn Grace Holbrook typed in the original blank. I kept it in the back of a cedar box with my husband's letters and my own childhood photographs, not as a wound, just as a fact. The kind of fact you don't examine too often because you're not sure what examination will cost you. I open my laptop. Constance Aldridge Fenn. The results are immediate and extensive. She had been, it turns out, a significant figure in Canadian literary scholarship. Several published volumes on mid-century women's fiction. A long tenure at McGill. A Governor General's Literary Award nomination in 1994 for a collection of critical essays. The kind of career described in obituaries with words like rigorous and foundational and fiercely independent. The language used for women who were respected professionally and kept everything else entirely private. I find a photograph in a McGill alumni archive from 1989, a faculty reception. She is standing slightly apart from the group, holding a glass of wine, her attention directed somewhere to the left of the camera. Silver hair, strong cheekbones, a particular angle to the jaw that is direct and unself-conscious. She is wearing small gold earrings and the expression of a woman who is present in the room but not of it, observing more than participating. I know that expression. I've been told I wear it at parties. I put my tea down. The bone structure is not identical. I have my father's nose, whoever he was, but the way she holds herself, the set of the shoulders, the chin that lifts not with arrogance but with the specific self-sufficiency of someone who stopped requiring approval at a relatively early age. I have seen that in the mirror on mornings when I am moving through the world without anyone to account to. I sit with the photograph for a long time. Then I close the archive and open the property records for Inverness County, Nova Scotia. The Heritage House exists exactly as Paul Bryce described. It has been owned continuously since 1978 by a numbered company registered in Quebec that I cross-reference against the Fenn Estate documentation Paul emailed me before I left his office. Clean title. No liens, no encumbrances, property taxes current through this year. She maintained it for 46 years. A house she may or may not have visited regularly, a house she kept in the same way she kept the letter funded, functional, waiting. I find Gareth Soloway in a third search. He is 51 years old. A sessional lecturer at Concordia, 2 published academic books with modest circulation numbers, a faculty profile photograph in which he looks like a man who expected more from his career by this point. He supervised the Fenn Estate's literary correspondence for 10 years. His name appears in the acknowledgments of Constance's last published volume as her most trusted scholarly companion. The phrasing is the kind that suggests he believed his position was permanent. I call my lawyer. His name is David Theriault. He's been practicing estate and property law in Ottawa for 22 years, and he answers his own phone before 9 in the morning, which is one of the reasons I've used him for 15 years. David, I say, I need you to do some preliminary research for me, quietly. Nothing filed. I need everything available about the estate of a woman named Constance Aldridge Fenn and about a numbered company registered in Quebec that holds title to a Cape Breton property. I also need to know whether anyone has filed any challenge or expression of interest regarding this estate in the last 90 days. He asks if he should be concerned. Not yet, I say, but I want to understand the full shape of it before anyone knows I'm looking. He calls me back in 72 hours. His first words are not an answer, they are a question. Evelyn, who have you told about your interest in the Fenn estate? I'm at my dining room table with my reading glasses on and 3 library books about Cape Breton property law open in front of me, which tells you something about how I spend the days since that meeting. No one, I say. Why? A careful pause. I made 2 inquiries through intermediaries, both routine. Within 48 hours, I received a call from a lawyer named Isabelle Cote of the firm Cote Marchand in Montreal. She said she was conducting a general review of the Fenn estate on behalf of its literary executor and wanted to know whether I was researching the estate on behalf of a client. David's voice is dry. She was not casual about it. She knew which records I had accessed. I take off my reading glasses. What did you tell her? That I research many estates and that my client list is confidential. He pauses. Evelyn, Gareth Soloway has someone watching the estate files. When I moved, he moved. That's not coincidence. No, I say, it isn't. I look out my dining room window at the canal. February ice, almost fully thawed now, the particular gray-blue of an Ottawa March. I think about a woman who spent 46 years maintaining a house on a Cape Breton shoreline, paying the taxes on it, keeping it ready. I think about a man who spent 10 years sitting beside that woman in her final decade, believing he had earned something that was never his to inherit. David, how quickly can you get me the full picture? Unzunk, sinzunk, what claim, if any, he could legitimately advance? He tells me he'll have it in 4 days. I give him 3. We settle on 3.5. The call from Paul Bryce comes on a Tuesday. I'm having breakfast when he calls, oatmeal and a second coffee, the newspaper open to the arts section. He apologizes for calling early. I tell him not to. Miss Marchetti, he says, I want to notify you of something as your point of contact for the Fenn estate proceedings. Yesterday afternoon, someone contacted our firm's administrative line, claiming to be a family member, conducting welfare checks on potential estate claimants. They asked about your general health status and whether you had legal representation currently in place. He pauses. They identified themselves as your niece. I don't have a niece, I say. No, his voice has the careful flatness of a man reading from notes. Our receptionist declined to provide information and flagged the call per our protocols, but I wanted you to know. The caller gave a callback number that, when we checked it, belongs to a private investigations firm in Montreal. I put down my coffee. Paul, I'd like a written record of that call. Date, time, the name and number given, the exact nature of the questions asked, today if possible. I'll send it this afternoon. I end the call and write the name Isabelle Cote in the notebook I've been keeping since that first meeting in his boardroom. I draw a line from her name to Gareth Soloway's name, which is already circled twice. Then I write, Private Investigator. Welfare check framing, looking for what? Cognitive vulnerability, health issues, signs of pressure. I recognize the shape of this. I spent 31 years at a national archive. I know how information is assembled, and I know what people are looking for when they ask about an older woman's health and legal representation in the same breath. They want to know if I can be managed. I call David, then I call my doctor. Dr. Priya Nambiar has been my GP for 11 years. She is thorough, unsentimental, and constitutionally allergic to vagueness, which is why I have never once considered switching to someone else. She confirms, when I ask, that she received a request 2 days prior from a health services coordinator claiming to be following up on a patient referral. The coordinator said I had recently flagged concerns about memory difficulties and wanted my cognitive assessment records forwarded to a specialist clinic for review. Priya's voice, when she tells me this, is very precise. I declined and flagged the request for irregularities. The clinic name she provided does not appear in any registry I can find. The referral authorization she cited doesn't match any form our office uses. She pauses. Evelyn, what is happening? I'll explain shortly, I say. Right now, I need a written account of that request. The date, what was said, every detail you have. She has it to me within 2 hours. The fabricated clinic name is Northfield Cognitive Associates. I search it, it doesn't exist. So there it is. The same architecture, different city. A manufactured institution with a credible-sounding name, deployed to access the medical records of an older woman in the middle of an estate dispute. The objective is not a diagnosis. The objective is the appearance of one, the suggestion that the claimant may be confused or easily influenced or unreliable. A shadow of doubt, filed early enough, can slow a proceeding for months while someone else moves their pieces into position. I note the name of the fictional clinic in my notebook. I add it beneath the line connecting Cote to Soloway. Then I call David back and ask him to add my doctor's documentation to the file we are building. 3 days later, a letter arrives at my house by registered mail. It's from Cote Marchand. It is formally worded and professionally correct in every visible way. The substance is a request that I submit to a voluntary cognitive assessment before proceeding with any estate claims, citing my age and what the letter describes as the complex and emotionally significant nature of the inheritance situation. The letter suggests this is in my best interest. I read it twice. Then I make a fresh pot of tea and read it once more. The framing is precise enough that someone less familiar with institutional language might find it reasonable. That is intentional. A letter like this is not written to convince the recipient. It is written to create a paper trail that can later be used to suggest the request was made in good faith and that I either cooperated or refused to cooperate. Both outcomes are useful to the person who sent it. I photograph the letter, email it to David, and note the date and time of receipt in my records. Then I go for my afternoon walk along the canal, because I walk every afternoon regardless of what is happening in my legal life, and because the discipline of ordinary routine is something I have found to be genuinely protective. When I get home, David has already called. He found something. Evelyn, he says, I've been through the Fenn estate records and Gareth Soloway's position carefully. Legally, he has no standing. He was listed as literary executor, which gives him authority over the publication and archival management of Constance Fenn's academic work. It does not give him any claim to the property or the physical estate. He pauses. But he filed an application 12 days ago with the Quebec court to have himself appointed as general administrator of the estate on the grounds that no qualified heir has come forward within the required period. That period, I say. When does it close? 63 days from the date of the application. He pauses. That gives you just under 7 weeks. And the Cape Breton property? The library? Both fall under the estate pending resolution of the heir question. If Soloway is appointed administrator, he controls access to and disposition of those assets. He would not technically own them, but he would control them. And David's voice is careful here. An administrator with no competing heir and a cooperative literary executor arrangement in place can make a great many decisions about an estate that are very difficult to reverse afterward. I sit down at my kitchen table. Outside, the March light is shifting toward evening. The canal would be catching it right now, that particular amber color that lasts only about 20 minutes this time of year, and that I have always made a point of noticing when I can. David, I say, how quickly can we move? The DNA question is first, and it's not a small one. Constance Fenn has no living immediate family. There is no sample to compare against mine directly. But Paul Bryce, when I call him, tells me what I half expected. Constance had anticipated this. There is, preserved with her will in a sealed biometric envelope, a certified hair sample taken with her written authorization in the year she updated her will. She wanted this to be a door that could actually be opened, not just a door that could be pointed at. Virginia built her door the same way, I think. And then I stop, because this is not about Virginia. This is about Constance, and about me. The DNA authentication goes to a certified laboratory in Toronto with legal standing for estate proceedings. It will take between 8 and 12 days. In the meantime, David files 2 things in the Quebec court. First, a notice of potential heir, which formally pauses Soloway's administrative application pending the outcome of the authentication. Second, a statement of documented concern regarding the conduct of parties connected to the estate proceedings, the fabricated clinic request, the private investigation call to Paul Bryce's office, the registered letter requesting voluntary cognitive assessment. David tells me, when he calls to confirm the filings, that Côté Marchand will have been notified within the hour. I imagine Gareth Soloway getting that call. I imagine the particular quality of silence on his end of the line. He calls me himself that evening. I don't answer. He leaves a voicemail. His voice is reasonable, measured, the voice of a man who has had significant practice presenting himself as the most sensible person in any room. He says he would appreciate the opportunity to speak with me directly, that he believes there has been a misunderstanding about his intentions, and that he has dedicated a decade of his professional life to preserving Constance Fenn's legacy and feels strongly that her wishes should be honored. I listen to the voicemail once. Then I save it, note the time and date, and email it to David. David calls the following morning. Did you listen to Soloway's message? Yes, I say. Isabelle Côté called my office this morning as well, he says. Less measured. She characterized our filings as aggressive and premature, and suggested we were acting without full knowledge of the estate's complexity. A pause. She also mentioned, in passing, that her client had been managing the Fenn estate's affairs for a decade, and that the courts tend to view long-term caretaker relationships with a degree of recognition. I let that sit for a moment. She's trying to build a caretaker claim, not legal standing, just the impression of it, enough to muddy the hearing. That's my read, David says. Which means they know the authentication is likely to go against them, and they're building an alternative argument for why Soloway should retain some control regardless. He won't, I say. I know you believe that, David says carefully, but I want you to understand that administrative control and legal ownership are 2 different tracks, and he's been working the first one for 10 years. That's why we file the ownership track clearly and completely before the hearing, I say. I want every piece of documentation about that Cape Breton property, every tax receipt, every maintenance record, every communication between Constance and the property manager entered into our submission. I want it absolutely clear that this property was maintained with intention and with an heir in mind. I want the court to read our filing and see 46 years of deliberate preparation. I'll have the submission draft to you by Thursday, David says. On a Wednesday afternoon, I receive a text message from a number I don't recognize. It reads, Miss Marchetti, my name is Renata Okafor. I'm a junior associate at Côté Marchand. I need to speak with you, not on behalf of the firm. Please don't respond to this number from any device connected to the office network. I read it twice. I'm sitting in my home library with a cup of cold tea and a survey map of Inverness County open on the table beside me. I think about this message the way I think about documents of uncertain provenance carefully, without rushing, considering both what it might be and what it might be designed to appear to be. I text back, "How did you find this number?" Her reply comes in 4 minutes. The notice of potential heir filing lists you as the party. It's a public record. I found it myself, not through the firm's search. I'm not supposed to be contacting you. I'm doing it because what I was asked to help prepare last week is not something I'm comfortable with. I think about this for another moment. Then I write, I'll give you 20 minutes. Tomorrow morning, the second cup on Bank Street, the one near Lansdowne, corner table. I'll be there at 9. She's already there when I arrive, which means she left early, which means she's nervous. She's perhaps 30, with the careful posture of someone who took this job seriously and is now discovering what that seriousness costs. She stands when she sees me, which I take as a sign of either good manners or genuine discomfort. I sit down and order a coffee before I acknowledge her directly. Renata, I say pleasantly, you have 20 minutes. Please use them. She does. She goes directly to what matters, which I respect. She tells me that Gareth Soloway received the notice of potential heir filing and spent an afternoon in Isabelle Cote's office the same day. She was present. The strategy they discussed had two components. The first was the administrative application she already knew about establishing Soloway as de facto manager of the estate, while the heir question was unresolved. The second was something she was asked to help research. Historical evidence that Constance Fenn had experienced cognitive decline in her final years, and that the decision to update her will had potentially been made under conditions of reduced capacity. She wraps both hands around her coffee cup. They asked me to go through the care home records, to find any notation, any incident report, any medication change that could be framed as evidence of confusion or diminished judgment in the period around the will update. She looks at the table. I found some. Constance had 2 episodes of disorientation in 2022 that were documented by the care home staff. They were assessed as transient, associated with a urinary tract infection, fully resolved within a week. Standard for someone her age. She looks up. Miss Marchetti, what they want to do with those records is not standard. I hold her gaze. What do they want to do with them? Present them without the resolution notes, she says quietly. Strip the context. Submit them as evidence of a pattern. I drink my coffee. The morning traffic moves past the window. A woman walks by with a small child on her shoulders, the ordinary, unremarkable machinery of a Wednesday in Ottawa. Renata, I say, are you prepared to document what you've told me? Not necessarily for immediate use. Just a written record date, what you were asked, what you found, what you declined to do, kept somewhere outside the firm's servers. She nods. I already drafted it. Last night. Good. I stand, leave money on the table for the coffee, and look at her steadily. I won't mention this conversation to anyone in a way that identifies you. But if this proceeds to a full hearing, what you know may matter. Make sure your documentation is complete and that someone you trust has a copy. She stares at me. You're very calm. I've been working with documents my whole career, I say. People who try to remove context from documents always leave a trace. The original records still exist. The resolution notes are still in that file. She can't undocument a UTI. I walk out into the March morning. The canal is 3 blocks away. I walk there before I get in my car, because some things deserve a moment of stillness before the next move. The DNA results arrive on a Friday morning. I'm at my kitchen table with my glasses on and a fresh coffee going cold when my phone shows a call from the Toronto laboratory. I answer it. The technician reads the conclusion to me in the careful language of certified science. Probability of first-degree maternal biological relationship between submitted sample and reference sample. 99. 94%. I set my phone face down on the table and look out the window for a while. The canal is visible from this angle in winter when the trees are bare. A narrow blue line between the bare branches. Constance Aldridge Fenn was my mother. I say it quietly, out loud, to no one. The kitchen is empty. The words land in the room and stay there. She was 22 when I was born. A graduate student at McGill, a scholarship student from a family in Sherbrooke that had very clear ideas about what happened to a young woman who became pregnant outside of marriage in 1960. She had been, according to the letters Paul Bryce released to me after the filing, there were 9 of them, written across the span of nearly 40 years, a woman who made that decision under pressure she did not fully choose, and who spent the rest of her life with the particular grief of someone who gave away something irreplaceable and never entirely stopped knowing it. "I was not permitted to keep you," she wrote in a letter dated 1987, which would have been the year I was married. "I have thought about that word for a long time. Permitted. As though you were a possession that could be given or withheld by the people who held the circumstances around me. You were not a possession. You were a person I brought into the world and then watched disappear into another one, and every October since your birthday was in March, but October was when I knew I would never stop thinking about it. Every October I make a meal I used to make when I was a student, something my own mother taught me, and I eat it alone and I think about who you might have become. I imagine you capable. I imagine you someone who knows her own mind. I don't know why I believe that. I suppose I believe it because I know myself. I read that letter 3 times, then I make a fresh cup of tea and I call David. File everything, I say. The DNA results, the full documentation package, Renata Okafor's account, all institutional records, Paul Bryce's written account of the welfare check call, my doctor's statement about the fabricated clinic. I want the hearing submission to be so thorough that the court can see not only what Constance intended, but exactly what was done to prevent it from being honored. A long pause. I want it on the record that this was not a passive estate dispute. This was an active attempt to discredit a 63-year-old woman's mental faculties in order to redirect assets that were never intended for the person attempting to redirect them. David is quiet for a moment. You have quite a file here. I've spent 31 years in an archive, I say. I know how to build a record. The hearing is held in a Montreal courtroom on a Thursday morning in April. It is procedural, not a trial, which means no gallery, no jury, just a judge's bench, 2 tables, and the focused attention of people who understand that official things are being decided. I sit beside David. Across the room, Isabelle Cote arranges her papers with the careful confidence of a woman who has been in many courtrooms. She is polished and prepared, and none of that frightens me. Gareth Soloway sits behind her. He is older in person than his faculty photograph suggested, with the particular tiredness of a man who has been waiting for something for a long time and is now discovering that waiting was the wrong strategy. He looks at me once. I look back without expression. The judge is the Honorable Claire Beaumont. She is 62, with close-cropped white hair and reading glasses she wears on her face rather than pushing up onto her forehead, which tells me she intends to read. She opens the folder on her bench, reviews it for a full 2 minutes in silence, and then looks up. I've read the complete submission from the potential heir, she says, including the documentation regarding third-party contacts. She turns a page. Miss Pepys and Rady, Thériault, your client is claiming inheritance rights as the biological daughter of Constance Aldridge Fenn on the basis of a DNA authentication result and a written testamentary instrument prepared and signed by the deceased 14 months before her death. Is that accurate? That is accurate, Your Honor. And your submission additionally includes documentation of a request made to a medical practice using the name of an unregistered clinical entity. She looks at her notes. Northfield Cognitive Associates, which does not appear in any provincial or federal health registry. Correct, Your Honor. We have submitted the original records request, the attending physician's written account, and the results of our search confirming the entity does not exist. Judge Beaumont turns to the other table. Miss Cote, your administrative application on behalf of Gareth Soloway was filed on the basis that no qualified heir had come forward. A potential heir has now come forward with DNA authentication and a valid testamentary instrument. What is the current basis for your client's application? Isabelle Cote rises. She is smooth and she is fast, and she is good at what she does. She argues that the DNA result, while significant, requires further contextualization within the full estate proceedings. She argues that Gareth Soloway's decade of literary executor service represents a relationship of professional trust that the court should weigh. She mentions, briefly but deliberately, the care home documentation from 2022. Judge Beaumont lets her finish. Then she says, calmly and without looking up from her folder, the care home documentation you've referenced includes resolution notes indicating the episodes cited were assessed as transient and fully resolved. Were you planning to submit those notes as part of the same exhibit, or separately? A pause that lasts exactly long enough to say everything it needs to say. Miss Cote, the judge continues, I'm looking at a DNA authentication result with a probability of 94%, a testamentary instrument prepared while the deceased was under documented physician-certified capacity, and a pattern of third-party contacts directed at the claimant's medical and legal representatives using, in one instance, a fabricated institutional identity. She closes the folder. The administrative application is dismissed. The DNA authentication is entered into the record. The Fenn estate, including the Cape Breton property and the archival collection, passes to Evelyn Grace Marchetti as the biological heir named in Constance Aldridge Fenn's will. She looks at both tables. I'm additionally directing this documentation to the Law Society of Quebec for review of the conduct outlined in the claimant's submission. We're adjourned. The room reorganizes itself with the quiet efficiency of a proceeding that has reached its end. I don't look at Gareth Soloway. I look at David, who is writing something on his notepad with slightly firmer pressure than usual, which I have learned is how she shows that something has gone exactly as it should. In the corridor afterward, I hear Soloway's voice behind me. He's talking to Isabelle Cote in a low, urgent tone, the voice of someone whose plan just became expensive. I don't turn around. David and I walk to the elevator and step in, and as the doors close, I have one last glimpse of a man in a good coat standing in a marble corridor, recalculating. The drive back to Ottawa takes about 2 hours. I make it in silence, no music, just the highway and the spring fields going green on either side of the 417. I think about the letters, 9 of them, written across 38 years, by a woman who had learned to hold an absence the way you hold something fragile carefully, always aware of it, not setting it down. I think about the October meals, the dish she made alone each year in the fall, thinking about a daughter born in March. I think about a woman who did not have the language in 1960 to push back against what was decided for her, but who spent the next 4 decades building quietly, carefully, in the way that careful people build not loudly, but lastingly. She kept the house, she kept the letters, she kept a certified hair sample in a sealed biometric envelope because she was, at the end, a scholar, and scholars know that evidence is what makes a claim real. The Cape Breton property is mine. The library of 4,000 volumes is mine. 17 unpublished manuscript drafts, her handwriting on every page, her thinking archived and intact, are mine to decide what to do with. I already know what I'll do. I'll work with a publisher to release the manuscripts properly edited, properly credited, under her full name. I'll establish a small bursary at McGill for graduate students in literature, especially those who are the first in their family to pursue an advanced degree. And I'll go to Cape Breton in the summer, to the house on the Broad Door shore, and I'll stand in the rooms she stood in, and I'll bring the letters with me, and I'll read them there, where the water is, where she chose to keep something waiting. My adoptive mother used to say that love was less about where things began and more about what you did with the time you had. She was right. She was right about most things. I carry her with me the way I carry Louise's ceramic teapot daily, without ceremony, as a fact of how I live. But I carry Constance now too, in a different way. In the way you carry something you've only just been given, carefully, not entirely sure yet of the weight, but already certain you won't set it down. There is something I've learned from all of this that I didn't expect to learn. I expected to learn about inheritance law, about how estates can be hidden and found, about how documents outlast the people who write them. I learned all of that. But what I didn't expect was this. The most important thing a person can leave behind is not property or money or even words. It's evidence that they thought about you. that they built something with you in mind before they ever knew your name, that they held a door open in the dark and trusted that the right person would eventually find it. Constance Fenn held that door open for 63 years. I walked through it. And what I know now, standing on the other side of it, is that the people who tried to close it, the fabricated clinic, the stripped records, the manufactured doubt, they were not just attempting fraud. They were attempting erasure. They were trying to make it as though a woman's deliberate choice, made in the last clear-eyed months of her long life, simply hadn't happened. It did happen. It is in the record now, filed and sealed and permanent, the way things in archives are permanent. You cannot remove context from a document without leaving a trace. And you cannot undo what has already been properly witnessed. That is the lesson of archives. That is the lesson of this. What is built with care, documented with honesty, and preserved with intention will outlast every person who wished it hadn't. Constance knew that. She spent her career teaching it. Now I know it too.